Hi, my name is Guillaume Henry. I'm a lawyer in Paris, France, and I specialize in intellectual property law, that is to say, in patent and trademark law and copyright. Today, I want to talk to you about a subject that I've been working on for several years: the link between patents and the transition towards a more sustainable economy. The question is simple. It's to determine whether patents are an incentive or an hindrance to the widespread introduction of clean technologies, and therefore the transition towards a more sustainable economy. Since 2010, I've conducted 3 successive studies on this subject, including the latest for INPI, the French Patent and Trademark Office, which was presented in December 2015 at COP21. Today, I want to sum up the results of my research. To understand this problem, we need to know that we face a double challenge in technology. The first is to encourage investment in clean technologies, because their efficiency needs first of all to be improved. The second is to disseminate these technologies quickly and on a large scale, so that the transition to a clean economy has a chance to have a positive impact on the environment. In recent years, the role of patents in the climate change debate is at the heart of a passionately debated negotiation during the Climate Change Convention. In short, some developing countries argue that they are not able to perform their ecological transition because of patents held by companies in developed countries that refuse to make their technologies available to them. Let me give you a short example. In 2010, during the Cancun conference, the president of Ecuador, Rafael Correa, made the following statement: "A fundamental theme for the southern country is to make technologies to combat climate change available, which requires that these technologies are in the public domain and are not covered by intellectual property rights." Yet, after carefully studying the role of patents in the fight against climate change, I came to the conclusion that patents are not an obstacle for developing countries to access clean technologies. Here is why. The patent is an intellectual property right which gives its holder a monopoly. This means that during the patent time of protection, the owner is the only one to be allowed to exploit it. That is to say, to reproduce the invention and to sell the products. One of the features of the patent right is that it is territorial. So every patent protects the invention on a single national country. Therefore, if an inventor wishes to protect his invention in 10 countries, he must file a patent application in each of the 10 national offices. The consequence is that the costs are high, because the inventor needs a counsel, a patent attorney, in each country to file the application. He also has to pay translation and annuities, which are annual sums to extend the life of the patent. The consequence of this territoriality of patent rights and the cost generated is simple. Patent holder must establish a strategy to file their patents only where it's strictly necessary in order to prevent excessive costs. In practice, a company usually files patent in following countries. Firstly, in country where the headquarters and main production unit are located. Next, in country where the main markets are located. And finally, in territories where its main competitors are active. The consequence of this filing strategy is that in developing countries, the vast majority of inventions are not patented, for the simple reason that manufacturers didn't consider these countries as markets. This is also true for clean technologies, and it is shown by a statistical study we conducted on green patent in developing countries. For example, we see on the table that in Vietnam, in the field of photovoltaic technologies, no patent was filed, and in Ecuador, only 2. On the contrary, around 24,000 patents were filed in Japan, and around 10,000 in the United States. But in emerging countries, the number of patents is also low, 32 in Malaysia, 52 in India. As an exception, 12,000 patents were filed in China, which is obviously due to its huge market. And the figures are similar for wind power patent or biofuel patent. Therefore, it is clear that in developing countries, and to a lesser extent in major emerging countries, that patents for clean technologies are not being filed. This means that in these countries, green technologies are completely free. So there, any company can manufacture and sell its products. The other consequence of the absence of patent in developing countries is that it is useless to provide a compulsory license. The compulsory license is the authorization granted to a company to exploit a patent against the will of its owner. But if a patent is not filed in a country, a compulsory license is meaningless, since the invention is free. The conclusion here is that patents are not blocking access to clean technologies for developing countries. Yet, it must be recognized that there is a challenge, since developing countries can't seem to accept these technologies outright. It seems the difficulty lies not in the access to patents, but in the specific know-how and expertise about how they can be implemented. Remember that to implement a technology, certain expertise must be available, as well as an organizational and commercial know-how. And this is what is lacking in developing countries. The challenge for developing countries is to convince holders of clean technologies to transfer their know-how to them. This is and will be the most important issue in the future. And this is the purpose of many initiatives such as WIPO Green or the Green Fund, to incentive the transfer of green technologies and know-how to developing countries. I'm of course at your disposal for any supplementary information you may need. Do not hesitate to leave any comments, and if you like this video, please share it. Thank you, bye.